I raised several issues in this case. For purposes of argument today, I'm going to try and focus on the evidentiary rules issue. The first issue that was raised dealt with the warrantless search of Mr. Stasher's vehicle. But I think after reviewing the written briefs, there might be some benefit to going through the evidence arguments and trying to clearly lay those out. It made a whole lot of sense to me when I was in the middle of this record, and when I went back to it cold, maybe not so much, but I think it's all there.
We all have that.
Hopefully I don't have this often. But anyway, on the evidentiary rules, there are really three rules at issue here. So we have Rule 404B, Rule 609, and then Rule 608. And then there are three prior bad acts or convictions, whatever you want to call them. There's a 2014 conviction for possession of a weapon. There's a 2019 conviction for possession of narcotics. And from that same incident, which occurred in 2018, there's a charged only conduct for possession of a weapon. Before trial, there were preliminary hearings held on 404B and 609. At the pre-trial hearings, the trial court essentially said, I'm going to defer any ruling on 404B. We'll address that issue if it comes up at trial. And for 609, the state essentially agreed or conceded that it would only seek to impeach Mr. Stasher should he choose to testify with the narcotics possession from 2019. We moved to trial.
Can I?
Yes, Your Honor.
I had a little, this is all confusing, so
Yes.
you're not the only one.
Yeah.
I was a little confused about that 2019 cocaine conviction because my reading was that they had agreed that it would be admitted as substantive proof of the fact that the defendant was a felon.
It looks like that's the ultimate conclusion that they came up to. And so I was just about to explain that at trial, this wasn't bifurcated. I think a lot of times, and probably the best way to handle this, exactly. We can all say that in the microphone again. Best practice is to have a bifurcated trial, please, when you have a felon in possession.
For everyone watching.
That's right. Please, thank you. But that didn't happen in this case. Or a lot of times you see that it's stipulated to, and we'll just agree that there's a felony, whatever. That didn't happen here. So the state introduced the 2019 conviction as proof of his felony conviction status.
Just during their case in chief.
That's right, during the case in chief. There wasn't an objection to that because it looks like it was agreed beforehand that they would use that as that piece, to meet that piece of their burden.
So it's in there by agreement.
It is, and it at least doesn't have an objection specifically to it during the case in chief. As trial progresses, Mr. Stasher testifies, and after his testimony, the state then seeks to use, for some reason, that same conviction again for impeachment purposes, and they also raise the issue of 404B, and they also include the prior conviction for possession of a weapon from 2014, and also the charged only conduct from 2018. Which never resulted in a conviction. The trial court, they had a jury out, the trial court made findings under 404B and then later under 609, but at the conclusion of the jury out hearing, it said that it would allow the state to impeach Mr. Stasher with those pieces of evidence, the 2014 prior gun conviction as well as the charged only conduct, under 404B and also under 609. And then the state cross-examines Mr. Stasher. They ask specifically about the prior conviction as well as the charged only conduct. Mr. Stasher admits that he has a prior gun conviction, and then also he was charged with another possession, and he makes clear that that was only ever charged, that was disposed of through a plea agreement. He never was convicted of that offense. And then after Mr. Stasher testifies, the state calls a Detective Anderson, I believe is his name, who testifies almost exclusively about the charged only conduct of the weapon possession from 2018. I think his testimony also covers a little bit of the narcotics that were also found during that same time that ultimately resulted in a conviction, but by and large there was a gun there, this is what it looked like, this is where it was, those sorts of things.
Well, wasn't the I remember correctly, the gun may not have been the same model, but very similar to, and with an extended magazine, just like the one that the defendant was arrested with in this case.
Yes, Your Honor. That charged-only offense was nearly identical to the issue that Mr. Stasher was currently on trial for. And so that's really one of the big issues that we have with that piece of evidence, both under 404B and under 609. Under 404B and 609, they both include a weighing of probative value and prejudicial effect. Under 404B, this court, the Supreme Court, has cautioned it's a rule of exclusion, should only be allowed during extraordinary circumstances. And for both of those rules, there's a lot of caution about the prejudicial effect outweighing the probative value, making sure that that is thoroughly considered because of the likelihood that a jury will misconstrue what that evidence means or just convict a bad person because they're a bad person, as their prior record would show. So under 404B, there's an issue it really covers all three acts, but largely with the 2014 prior conviction for a firearm and then also the charged-only conduct. Both of those were substantially similar, if not identical.
But what do we do with the fact that that 2014 gun charge was agreed to be admissible?
That was the 2019
Or 2019,
drug
okay,
offense.
okay.
Yes, Your Honor.
Gotcha.
Initially, the state's position was it wasn't going to use either of the of the gun offenses at trial, but the drugs. I think if you're evaluating just that issue alone under 404B, then I lose. But if it's the gun issue,
The others, okay.
That's right. Yes, Your Honor. So again, we have more than just the convictions themselves being said in this case also. The state was allowed to question Mr. Stasher directly about both of those incidents, the 2014 prior conviction as well as the charged-only conduct under both 404B and 609. And it also, there was no objection to it, but it entered a certified copy of the conviction for the 2014 possession charge. And then again, it called Detective Anderson to testify extensively about the charged-only conduct. So I think that viewing those as far as is the prejudicial effect outweighing the probative value, it strongly outweighs any probative value.
Let me stop you just for 1 second. What was the purpose, the articulated purpose for this proof coming in that the court found to be relevant?
The court found that it related to identity, or intent, excuse me, not identity, intent. It made a specific finding of intent. And then it also repeated that Mr. Stasher had opened the door to these offenses. But even if it did relate to intent, that's only one piece of the puzzle for 404B. You still have to conduct the weighing analysis. And same thing for 609.
Wasn't the argument that I think the defendant's testimony was that this gun wasn't his, it was in the car, and he had no connection to it? And
he admitted that the vehicle was his, but he had a witness testify in his defense who was his brother. He testified, it might have been before Mr. Stasher, I honestly don't remember. I think it was before. But his brother testified that he was using Mr. Stasher's vehicle for some time prior to this incident, and that he was in town visiting Mr. Stasher, and then Mr. Stasher and his son were going to go to the store for cigarettes. And so they took that vehicle because his brother had just arrived and was still running, those sorts of things.
And it was his brother's gun, not...
The brother claimed ownership, yes.
Yeah.
He said it was his firearm, that he had purchased it. He just left it in the vehicle by mistake, and that Mr. Stasher had left while he was in the restroom, so unable to convey that there was a firearm.
And then the state's argument was that he had been arrested before with the same type of firearm, with the same type of configuration.
Yes, so that showed his intent then to possess the firearm on this occasion. And I mean, to me that
water. Do you agree with that?
I don't think so. I think that is purely what propensity is, like that he did it once before, so now he must have done it this time.
What about absence of mistake? Because I think the state mentioned that as well.
They did argue that. as well. That might have a little more validity to it, but to the best of my recollection, the trial court only found that it related to his intent.
Okay.
But I think under all circumstances, it's unreasonable to think that the probative value of those two offenses overcame any prejudicial effect that they would have had, such to be admissible under either 404B or 609. And as it relates to 609, the rule there is meant to allow impeachment, but there are specific parameters that are found within that rule and the case law that addresses it. Specifically, it needs to be a felony conviction, or it needs to be a conviction that relates to deceit, one's veracity, fraud, those types of things. In this case, I mean, I'll grant that this court and probably other courts have said that a felony in general has a flavor of being untruthful, any felony conviction, but you still have to go beyond that. You still have to conduct the weighing analysis, and you still have to view that felony conviction in light of how does it impact one's credibility or one's veracity as they're testifying. So that, I don't really believe that was done here. It certainly doesn't apply, that it was a felony conviction certainly does not apply to the charged only conduct. That should not have been admissible as impeachment evidence, my belief, full stop. It was not any conviction, and so the inquiry should have ended there. And then again, for the felony conviction, I don't think that possessing a firearm really bears on one's propensity to tell the truth or not. So I don't think that factor was met either. And then on top of all of this, again, we have that the proposed evidence, or the evidence that was ultimately used, is substantially similar, if not identical, to the same offense that Mr. Stasher is currently on trial for. And that should weigh very heavily in favor of this being more prejudicial than probative. And then, just to touch on 608, that rule governs the type of evidence that can be used to basically prove up evidence that's admissible under 609. So we have from Reed, it was a 2002 Tennessee Supreme Court case relying on Tennessee Rule of Evidence 608 that the evidence of conduct other than a criminal conviction may not be used to attack the character of a witness. So this rule, I mean, it kind of touches on the 2014 conviction, but there wasn't an objection to the introduction of the certified copy for that, so that is what it is. And it kind of touches on the possession of narcotics, but not directly. What this one really directly gets at is the testimony of Detective Anderson as it relates to the charged only conduct of possession of a weapon. For impeachment purposes, the state was allowed, even if the state was allowed to question Mr. Stasher about that charged only conduct, which I'm not saying that he is, but for the purposes of this, even if he was allowed to, then the state should not have been allowed to proffer the testimony of Detective Anderson, because he testified to specifics, that it was a automobile stop, that they searched the vehicle, that they found a gun, that it had the same type of magazine.
The state says they weren't relying on 608 below, that it was a 404B situation.
The trial court found under both 404B and 609 that the state could question Mr. Stasher about both of those incidents. So
609 wouldn't apply to the 2018 gun incident because it didn't result in a conviction, right? But
my understanding of the record is that the trial court made a finding and a specific ruling that the state could, under both of those rules of evidence, elicit this testimony. So if they're both going to be proffered under 404B and 609, then they both have to comply with all of the mandates of both of those rules, including 608 that says that you cannot introduce extrinsic evidence to prove up an offense. But that's exactly what happened here.
608 only pertains to impeachment evidence that attacks the credibility of a testifying person.
That's
right?
correct.
And with the 2018 gun incident, that's really not what we're talking about. It's not, he possessed this gun, so he must be a liar. You shouldn't believe his testimony. That's what 608 is.
That was, from my reading of the record, that's exactly the argument that was made below. That the state's argument was that under both 404B and 609, we can ask Mr. Stasher about both of these incidents. And if that's the case, then the state was also required to comply with 608 as it relates to that 2019 charged-only conduct, which Detective Anderson clearly didn't. And as explained in my brief, that's not harmless. There's no way. He was the last witness to testify. He testified extensively about another prior bad act relating to Mr. Stasher, and it was one of the last things that the jury heard before the case was turned over to them. So,
what about this argument regarding the racial profiling? It seems like that was used as a justification to bring in the 2014 firearm conviction.
The trial court seemed to, I realize I'm about to run out of time, so if I can answer the question.
We'll give you some time since we've asked the question.
Thank you. The trial court seemed to also say that Mr. Stasher had opened the door to these, the introduction of this evidence because he said that he had been racially profiled by the police before. But when someone opens the door, it's not like, well, now everything that you've ever done bad automatically comes in. It has to be related to and proportional to the testimony that, quote unquote, opens the door. So in this case, allowing in two other prior instances, one which was charged only conduct, that are substantially similar, if not nearly identical, to the offense that you're currently on trial for, is just beyond the pale of what a rational or a measured fix to that would have been. The state, if the state had been limited to only asking Mr. Stasher about other run-ins he'd had with the police, and if those had resulted in convictions, or how many times he'd been arrested by the cop, something like that, I think that would have been more proportional. This was just too far, essentially. Thank you.
General Ward.
Good afternoon, Your Honors. May it please the court. Garrett Ward here today on behalf of the state of Tennessee. Your Honors, like Mr. Raines, I will devote most of my time before this court to the sort of 608, 609, 404 evidentiary issues and rely on the state's brief for the probable cause challenge, unless, of course, this court has questions, in which case I'm happy to answer them. I guess to start with these evidentiary challenges, I'll again agree with Mr. Raines that this case is just a little confusing in terms of what exact acts and what exact convictions we're talking about at any given time, and what exact rule of evidence applies to them. There's some additional convictions that are discussed in pretrial hearings that haven't even made it before this court for argument. So,
but the trial judge did rule those out.
Yes,
those, but not these for some.
Correct,
reason.
Your Honor, and largely because I believe it's either volume 4 or 5. It's one of the pretrial hearings. The state is first discussing these three convictions: a 2011, a 2014, and a 2019. And the state, at that point in the pretrial hearing, essentially says, we're not gonna touch 2011. We're not gonna touch 2014. We'll introduce 2019 largely or solely to sort of establish this element of the felon in possession charge, because as this court has noted, this case was not done in a bifurcated proceedings, in a bifurcated proceeding, despite that probably being the preferable way for it to be done. So really, when we get to trial, sort of the lay of the land is all parties, the defendant, the state, the trial court, understand that what the state's going to do, they're just going to introduce the fact of the 2019 conviction for possession of narcotics to establish the element.
Did they actually introduce the conviction?
Yes, Your Honor. I believe it is Exhibit 3.
That's what I thought.
In the record.
Okay.
And there's some discussion. There's some redaction of some items on that judgment. when the state introduces it, but it's ultimately introduced with no objection, because the parties agree that that would be done. However, Your Honors, once we're at trial and the state, there's a jury out hearing and there's discussion of the fact that the defendant is going to testify, and then when the defendant ultimately does testify, that's what sort of starts to the wheels moving on. Is this 2014 conviction for gun possession going to come in? And is this 2019 charge only act going to come in? So I'm going to
Let's just talk about that. I mean,
certainly the
how
charge
is
only.
the charge only act, how is that okay?
So I two points on that, Your Honor, because candidly, when I was reading the brief in preparation for argument, my initial reaction was seems a little odd. But I think I'd point the court to two things, and those are largely things that spring from the way the defendant defended himself in this case on the stand. The defendant really has two large theories here to defend against this charge. And briefly, I'll note the charge is backed by pretty weighty evidence. When the defendant is pulled over, there is a gun visibly sticking out from under the seat that he's sitting in this car while he's driving. So his primary defenses against this pretty formidable evidence are, one, that my brother sort of secreted this gun here outside of my knowledge, and the brother testifies to that. I'll note the brother is not there. There's a passenger in the car at the time he's pulled over. It's not the brother. I guess the contention is that at some point in the past the brother did this. But the second defense that the defendant raises pretty vociferously in his testimony is that this incident between himself and Officer Cannon is just another instance of the Cookeville Police Department racially profiling him. He spends several lengthy paragraphs. It's around page 400, I believe, of volume 8. It might be volume 7. But he spends several lengthy paragraphs describing this theory that he's not done anything wrong in this case, that he's never done anything wrong, and that all of his troubles are just racial profiling. So the state, to sort of rebut this idea that there's just some sort of mistake, or that the gun is sort of inadvertently, accidentally, unbeknownst to the defendant, winds up under the seat he's sitting in, and to combat the fact that he is levying these fairly weighty charges against the Cookeville Police Department. That's why the state initially seeks to introduce this, or seeks to introduce this uncharged conduct, because it goes to, in the state's view, goes to absence of mistake. That is something the trial court might not have directly said that, but the state does clearly say that when it suggests for the first time that it wants to discuss this conviction. The state says this goes to absence of mistake.
As to which theory? Because I've been thinking of that in the context of the this is my brother's gun theory.
I think it more fits in bucket one, Your Honor, that rebuts the theory that this is my brother's gun.
Okay. What does an incident from 2018, how would that rebut that mistake? Because I'm thinking, let's say the defendant had got into a fight with some dude the week before and showed him a gun, and the party said, look, we've agreed we're not going to talk about that at this trial, and then he gets up and says, this is my brother's gun. Well, then clearly that would be fair game that he possessed a gun, if it was the same gun, things of that nature. But something that happened so far ahead, how does that do anything but say he was carrying a gun then, he must have been possessing this gun now?
And Your Honor, I understand the court's concern there. My primary response would be that when the defendant, he is suggesting that this is his brother's gun, he's also raising these notions, although this absence of mistake, I think, primarily responds to the defense that this was his brother's gun. It's at least partially responsive to the idea that he's just the victim of this continuous racial profiling by the police department. And I think it responds to those two defenses in two distinct ways. First, as to sort of absence of mistake, if the defendant's claim is that this gun just accidentally wound up on the floor of his car, when combined with his suggestion that all of his previous run-ins with police have been non-meritorious, this previous run-in with police that where there was at least some hint of gun possession, this 2019 conviction, it does rebut those theories to some extent. And it's the defendant that puts these at issue. You know, and the state's case in chief doesn't touch these at all. But when the defendant gets up in front of the jury and makes sort of this hybrid argument that this is my brother, wasn't my gun, everything that has ever happened to me in front of this police department, including this incident, is just sort of virulent racial profiling. You guys know how the Cookeville Police Department is. He goes on for some time, and he really beats this drum, and which it follows his brother's testimony. So when the state has evidence suggesting that no, we have successfully encountered you, that you're not just the victim of this virulent racial profiling, I do think that at least rebuts the sort of racial profiling defense he's raised. And as for the idea that it's his brother's gun, Your Honors, I understand that at times when we're talking about 404B issues and we're dealing with absence of accident or mistake, that at times, though, that is a permissible purpose, and the black letter law from the Tennessee Supreme Court and this court is far, honestly, from before the adoption of Rule 404B, acknowledges absence of mistake as a proper purpose to introduce this sort of bad act evidence. At times it can appear, it can sort of resemble propensity evidence, but when a defendant raises a defense of sort of mistake, accident, it's just sort of popped up under my car, the law in Tennessee is clear that a permissible purpose for the state to introduce other act evidence is to show absence of mistake.
Well, it's still, the rule doesn't allow propensity evidence. As I'm reading the rule, that's barred.
That's correct, but the rule, as it has been interpreted by this court and the Tennessee Supreme Court, does allow absence of mistake evidence.
Which is other than propensity evidence. It can be admitted for other reasons, such as to prove absence of mistake.
Which is the purpose the state offered this for here.
Yeah, but yes, and I see where you're coming from when you say that, but when you really think about it, what the proof is, it's not a mistake that he's possessing this gun now because he has been convicted of possessing a gun in the past. I mean, isn't that propensity evidence?
And Your Honors, not to repeat myself.
I mean, I am. You can.
Yeah.
Well, then I'll follow Your Honor's well-trod path. Then.
I didn't say it was well trod, but
I'll say that for the record. And I'll acknowledge that there is, whenever we're dealing with absence of mistake, there is probably almost universally some similarity between some suggestion, some fear that this may be propensity. But despite that fear, the law in Tennessee is crystal clear on this, that absence of mistake is an appropriate purpose that the state can introduce.
Is there any case law at all where this has come up, where to show absence of mistake on a gun charge, you use a prior gun charge?
I haven't found something that's on all fours, Your Honor. I would love to be able to offer this court a case just to resolve the issue.
It's just so hard, as you see, when it's the exact kind of same charge. And then again, I'm still hung up a little bit on the charged only, the non-conviction.
Certainly, and I'll apologize if I'm muddying the waters between those two a bit. It is probably, it's not the first time, probably won't be the last time that
this whole case
these get muddied in this case.
I think we've all agreed. We can all agree on that.
And I get, the part about the uncharged thing, and you can, let's say you're correct in saying that you can get into the fact he was charged with possession of a weapon that doesn't result in a conviction. Let's say you can do that. Getting into the extrinsic evidence and the detail that went into this case, does that go beyond the exception to allow that proof in by going into a lot more detail about the circumstances, the underlying facts of that arrest, And again, it's sure, when you start talking about, you talk about propensity, oh, it just happens to be the same type of gun that he got caught with here, the same type of extended magazine. I mean, it is basically the same case as this one.
Mm-hmm.
I mean, prejudice means something, and when you're looking at this, how does this not, even if you come in and say it was showing absence of mistake, how do you get around the prejudicial effect of this when it is basically identical and it's not a conviction, but it's basically identical?
Certainly, Your Honor. And candidly, if I were to draw this case in a lab, if I were to have, designed this case in a lab for myself, the testimony probably would not have been exactly as it was. But just to directly respond to your question, Judge Campbell, I think what the trial court is really looking at here when the trial court makes its ruling, because the trial court does make sort of the requisite 404B ruling here, it follows the steps. So we are on abuse of discretion. So when the trial court makes this ruling, it is looking at it considers the similarity of this prior conduct to the conduct at issue. In this case, the trial court wasn't sort of blindsided by this testimony. The trial court, when it makes its ruling, understands, look, there's some similarity. But when and I understand that to some extent that does raise the sort of, if we think of 404B as scales, that adds weight to the prejudice scale, but it also adds some weight to the mistake of fact scale. And the trial court here is conducting this weighing exercise, and it comes to a decision, and it might not be the decision that every mind would reach, but when we're here on abuse of discretion, which is the standard of review, the question is really, does the trial court come to a decision that a reasonable mind would reach? And I think here maybe it is a close call, but I think a reasonable mind could reach the decision that the trial court reached and appropriately admit this evidence under 404B. I hope that addressed Your Honor's question. And since we're sort of talking about harm, I want to briefly step back from fighting the merits or discussing the merits of these two issues and address harmless error at least a little bit. And what I want to focus my harmless error argument on is the facts of this case. The defendant is driving this car. When he's pulled over, a gun is seen. I believe the words of Officer Cannon are, he sort of says, I stuck my head in the door, and as soon as it was there, I just see the handle of this pistol sticking out from under the driver's seat. This court has repeatedly noted that sort of possession charges when we're dealing with weapons in automobiles will often look to it was the defendant, the driver, is really weighty evidence in favor of a finding of possession. And I'd suggest that that's more so when the weapon is found under the driver's seat, and is even more so when the weapon is just sort of sticking out from under the seat. I understand the court's concerns about the discussion of his prior convictions, but when we're considering harmfulness in the sort of evidentiary rules context, what we do need to what we have to focus on is what tipped the scales, and what tipped the scales here was the fact that the defendant was driving this car and there was a gun sticking visibly out from under the seat he was sitting in at the exact instant he was pulled over.
But he offered an explanation.
He did.
And instead of the jury listening to the testimony of his brother and seeing if his explanation was credible, what we have now, I mean, got to admit, when the jury hears that this guy has been carrying around 2 guns prior to this case he's toast, right?
It certainly didn't help him.
I mean, if they were on the fence at all, when they heard that, he was getting convicted of this possession charge.
And I understand that, Your Honors, but I think reasonably I think viewing sort of this entire case, reasonably they're not on the fence. I understand he offers this defense that his brother at some nebulous time hides this gun under his car or under his seat in a way that it's immediately visible to anybody looking in the car, and the defendant didn't know anything about it. I understand that's his defense. That's the first defense combined with this racial profiling defense.
I mean, I wasn't there at the trial. I don't know.
Certainly.
It could have been a load of malarkey. It could be a very reasonable explanation.
And
we don't. That's the beauty of what we do. We don't see the
Certainly.
trial. We just work from the record. What do you make of Mr. Rain's suggestion that you could have got to the same point here? Not you, the state could have, by tailoring the proof that was introduced. Like if you want to attack the racial profiling thing, say, okay, you've been pulled over how many times, you've been arrested how many times, you've been convicted how many times, you pled guilty to how many of these instances, to kind of rebut that without getting into the specific facts of you were carrying a very similar handgun in the very same spot that this one was found.
And Your Honors, as is often the case when we're talking about decisions made by the state below, there were other paths the state could have taken. The state could have presented the evidence in a different way, and maybe even this court would prefer for them to have presented the evidence.
Well, especially
in a separate way.
in this context where you've said we're not getting into this stuff. We're not talking about these incidents during this trial.
Which was the state's sort of initial plan, was to leave this alone until
Sure.
the defendant, in the state's mind, puts this squarely at issue by asserting these two defenses that I've discussed.
Yeah,
before.
and that happens, and that things can change in the course of the trial, but it just seems to me that when that happens, it's especially important that you follow that rule that we hear about opening the door, that it's strictly tailored to how far the door was opened.
And I completely agree with Your Honor, but when it comes to opening the door in this case, the defendant rather kicks it open. When it comes to the testimony he offers about his history with the Cookeville Police Department, this isn't some passing reference. He goes on for at least about two full pages of almost uninterrupted testimony, not question and answer, 2 pages. Just the defendant talking with no interruption about how the Cookeville Police Department is, thus in such a way and just does this. So the defendant doesn't crack the door open to rebutting some of these charges. His contention is that I have had these encounters with police and they're all malarkey, to borrow your word, Judge Hickson, that they're all malarkey, and what the state is trying to do is to say, no, they're not. We have encountered him in the past. He is saying we have done this for no reason whatsoever, but we didn't do that then and we're not doing that now. And I see I'm out of time. I'm happy to answer any other questions this court may have about this funny little case. Otherwise, I would ask that you affirm. Thank you, Your Honors.
Thank you.
General.
Mr. Raines? You've got your full 4 minutes.
Thank you, Your Honor. Just briefly, I'd like to first address, I guess, the racial profiling issue. The state's interpretation or explanation, whatever you want to call it, of this is that was central, or that was essentially the entire purpose of Mr. Stasher's testimony. That is not the case. His testimony spans probably close to 20 pages, if not more, excluding the jury out hearing. And I have 2 pages, 398 and 99, as where he discussed this racial profiling that he had experienced. And that comes about after he had already admitted that upon reviewing the video, it looks like his tire went off the road, and he fully admitted that the window tint was too dark. And then it comes up again on page 430, and that would have been during the state's cross-examination. So, it was definitely something that Mr. Stasher said, but I don't think that it was to the level of my entire theory of my innocence is that the state was racially profiling me.
Here's what I got out of it. And again, I'm looking at it, as Judge Hickson said, we're looking at it strictly clinically, I guess, just from the transcript. But his 2 points were, wasn't my gun, it was my brother's, and the officer put something in the car when he was looking at it.
To the second one, I don't read the record that way. That very well may be if that's how.
I got is that they tried to they planted something on him.
Yeah, I do recall him talking about explaining the reason why he ran is because he wanted to take the heat off his son, and if you're going to put anything on me, put it on me, that sort of thing. He was trying. There was a phrase where like "put it on me" or something like that, where he explained at trial that was if the police were going to arrest anyone or take anyone to jail, it should be him and not his son, because the passenger was his 15-year-old son. So that might be where we've drawn a distinction between that testimony. So I don't think that it was a credible argument by Mr. Stasher that the police had planted the gun on him, because
I'm not saying a gun, but I think he was at least intimating that they were going to set him up for something.
Yeah, I think that might be one interpretation from the discussion about why he ran.
Okay.
Perhaps I don't read it that way. I read it more as him explaining that. Even though to Judge Hickson's point, as it relates to harmlessness, this can't be extricated from the jury's decision at this point. It was 2 prior instances where Mr. Stasher was either convicted or charged with possessing a firearm. We have details about the charged-only conduct, enough to say that it's essentially identical to what he's on trial for. And the standard for harmlessness is not, oh, well, maybe, okay. It's can we pull out that information such that it didn't have any effect on the jury. And I don't think that can be said here, given the type of evidence that was presented and also when it was presented.
So what happens when a defendant, when he testifies, knowing all this stuff is out there, and he makes a statement that brings it all kind of into light? What is the limit?
I think that is a case-by-case specific point, first of all. So in this case, though, it would be again, when somebody opens the door, I don't think this door was kicked wide open, as the state suggests, but in this case, it would be a proportional remedy to that, which is, well, let me judge from the state's perspective. Judge, let me ask him about all the times that he's had involvement with the police, right, and how many times those have been resulted in a conviction, or what the disposition of those were, without getting into specifics, especially specifics like this. And then just finally, I'll note that even if there is a permissible purpose under 404B to allow evidence in, say it was a mistake, say that's good enough to carry water, it still has to survive that propensity or the probative value and prejudicial effect weighing. And in this case, given the similarity of the offenses, given the time that it came up, all the circumstances for which this occurred, I just don't think that you can say that it was more probative than prejudicial. And for that reason, we'd ask that this be remanded for a new trial, or if you agree with us on the search warrant issue, that Mr. Stasher's convictions be vacated. Thank you. Thanks for letting me go over a little bit.
Sure. And thank you all for being here today. I know the Attorney General's office, y'all have several people that have filled in for your colleagues. I know they appreciate it. We appreciate it as well, so we can keep these cases moving and have oral argument. And it looks like I'm judging that maybe there are some interns from both offices here today.
Yes, sir. I've got 3 interns with my office.
Yeah. Well, we welcome you all. We have at least had some interesting cases for you to listen to, and probably a lot of things that you can learn how to do better, I'll just say it that way, in the trial court when you become lawyers, so that you don't create issues to come up on appeal. So we're glad that you all are here and hope you enjoy your summer internships. So anything else? No, you aren't. All right, then we are adjourned.